Hi there, and welcome again this week to the Employment Law Show. John Scholes here. Momentarily, Lior Samfiru on your screen. Of course, employment lawyer at employmentlawyer.ca. Always welcomed and encouraged to reach out to Lior with any employment questions you have in the workplace or otherwise. Even if you're an employer, always call Lior and his team. That number 1-855-821-5900. Email help at employmentlawyer.ca. As always, we've got a ton of stuff to get through in the show over the next half hour. We'll get to some phone calls from one of our radio shows across the country, emails, questions, and we have a main topic every week, which is super important, something to drill down on a little further in the second segment. This week it is 5 key questions employees should ask about resignations. That is all on the way, Lior, but we always get started with a week that was or a case of the day, something you want to bring up. What do you got cooking this week, pal?
Nothing but trouble. No, always happy to be talking. Always happy to be talking about employment law. That's what I have cooking. I lead a simple life. I answer employment questions. I resolve employment issues. That's what I do on the show. That's what I do when I'm not on the show. But it's because it's such an important topic that we have all this time and these topics to discuss. There's so many issues that come up with employment law. I speak with people every day when they're in a difficult situation. They lost their job, but of course, it's a problem. They have mortgage, they have other financial responsibilities. What do they do? Well, we talk about their rights, what they're owed, the money that they can get to cover them until they find another job. Or I talk to people often that have been mistreated in the workplace, people that their boss or a coworker, someone has created a poison work environment. Well, guess what? You have rights in those situations. There's things that you can do either to fix the problem or to get out of there with compensation. So we cover so many topics on the show, and I cover so many topics off the show. And there's still a lot more that we can cover for many years to come, and we will. So that's just a long way of saying that if you want to know about your rights, that frankly, everyone should know about their rights. This is the show and the time. But beyond just these 30 minutes, you can reach me in the office. We can have a private discussion. There's no bad questions, only answers and solutions. That's all there is. So don't ever hesitate to pick up the phone or to send an email. We'll give you that contact information throughout the show, so stay tuned for that. But as another example of the types of things that I see, let's talk about the case that came across my desk this week. I spoke with a gentleman who had been off on a disability leave for about a year. Recently, he received a letter from his insurance company saying that, well, based on our review of your doctor's notes, we think you don't qualify for disability leave anymore, and we're going to be cutting you off in a few weeks. This was a shock to this person because he couldn't work still. His doctor told him he couldn't work, so he didn't understand why he's being cut off disability benefits. So, but here came the insurance company, and they said, well, we're going to also allow you to appeal this decision. If you don't agree with us, you can appeal this decision. So he thought, well, that's a great thing. He appealed this decision. A couple weeks later, he gets a note back saying, we denied your appeal. It gets worse. His employer then contacts him and says, we understand that you're being cut off disability benefits and that your appeal was denied. That means you're able to come back to work. So you better be back to work in a week, or else we're going to consider you to have resigned. What a horrible situation. You're getting cut off disability benefits. You still can't work. Your employer's going to say you've resigned. Well, what do? Well, thankfully, he called me. So here's the first thing that I said to him. Number one is your insurance company should not and must not cut you off just because it thinks you're not disabled enough. They should follow what your doctor has to say. If your doctor knows you can't work and you know you can't work, that should be and must be enough for the insurance company. And by the way, these appeals, nonsense. It's a waste of time. They're never successful. It's just a way to make you feel like you've tried to do something so that then you become frustrated. Once the insurance company hears from myself, my team, they back off, they pay the compensation, they do the right thing. So right off the bat, we're going to help him deal with the insurance company. Now, with respect to his employer, same thing. It doesn't matter what the insurance company says. If he has a doctor's note saying he cannot work, he can be off work. His employer cannot say, well, that's a resignation, you better come into work. If your doctor says you cannot work, you provide that note to your employer, that's it. You're off work until your doctor clears you. So that's what happened here. I'm going to help him with both his employer and his disability insurer. If that happens to you, whether you're being cut off disability or your employer is not believing your doctor, call me and we'll make sure we help you.
Yeah, as you mentioned, Lior, that appeal process is an internal process. It's something that's thrown to you and offered to you by the insurance company themselves. It's not some arbitrator, some third person. It's, as you said, it's total total garbage. Don't bother with that. But how far do employers get to go? And what I mean is they listen to the insurance company saying, well, they say you should be back to work. So just to make sure, we want access to all your medical documents, and we want to hear your diagnosis and when you're going to come back and what's wrong with you. I mean, how far can that employer go in that regard?
Not far at all. Your employer needs to listen to your doctor. If your doctor provides clear instructions saying you cannot work, that should be enough. Your employer cannot demand your private medical information. They don't have a right to demand to know what the condition is, what treatment you're taking, what specialists you've seen. That is offside. They need to know, can you work and can you not work, or potentially what limitations you have. Hey, can we accommodate? Can we give you some other work to do in the meantime? Those are legitimate issues for the employer to know. When it touches on private medical conditions, that's offside. You don't have to provide that. You don't need to engage in that discussion. If your employer is threatening you inappropriately, let's get them off your back. And that starts by calling me.
You want to join us or listen to us on the radio show each week in various communities across the country. As you know, employmentlawyer.ca is where you'll find that information. Phone calls come in all week, not only privately off air to Lior, but of course on the radio show. We take them, we play them back, we all learn something from them. So in that regard, Lior, I want to get to our first radio show phone call right now, so listen up.
I was at work that I passed out. The week after that, I fully worked from home, and I got an invite. Please come to office on Monday morning. Got fired, and I thought they're letting me go because they think that I'm going to take disability leave. I'm a director.
And how long have you worked there for?
For 17 months.
What did they offer you for severance?
Only 6 weeks.
How old are you?
Going to be 44.
Okay, how do you navigate that one, right?
Well, certainly it is illegal. It's a human rights violation to let an employee go because they're sick or because you think they're going to take a disability leave. That is illegal. Now, of course, the question is, do we prove it and how can we prove it? Well, we look at the circumstances. If you're a good employee, never had an issue, and you're all of a sudden the only one that's been let go, no one else, and the only thing that's happened in the meantime is you became sick, well, it pretty much starts to look like you're being let go because you're sick. And again, that's illegal. If you're about to take a medical leave, a disability leave, and your employer lets you go to avoid that headache, well, that is a human rights violation. They cannot do that. So right off the bat, John, we have a human rights violation. The second issue is that of severance. So this person has been there for 17 months and was offered 6 weeks pay. Some people may say, that sounds okay. A year and 5 months, you were offered 6 weeks. That's not bad. It's bad. It's not even close. So let's see how much severance this person actually is owed. We're going to use our severance calculator tool. Of course, you can find that at pocketemploymentlawyer.ca. Let's use that right now and see what that gives us. So we know and we see on the screen that this person is 43 years old in a senior director role, been there for 17 months. Company says 6 weeks is all you get. Not so fast. You see there that this person is owed closer to 6 months, not weeks, but months. That's how much severance is owed. So now not only do we potentially have a human rights violation, we also have a wrongful dismissal. Remember, wrongful dismissal, simply a situation when you're being let go without proper severance. So use the severance calculator, pocketemploymentlawyer.ca, and you'll be very glad that you did.
All right, there's phone call number one. Let's get into phone call number two. Lior, listen up.
Buddy of mine was let go. There was some stuff with written notices and everything like that, so it wasn't a surprise. He wants to know if his severance is accurate or not. Says he's been there for just under 7 years, and they offered him about 10% of what his actual annual amount is. Is it only the base salary that he gets as well with severance, or does he get bonus pay?
What do you think?
Well, John, I mean, I've never actually heard it described in terms of 10% of annual salary.
Yeah.
Usually we look at weeks or months, but let's call it about a month's pay, roughly, is what this person was offered after 7 years. He's probably owed closer to 8 or 9 months' pay. So 7, 8 times what he was actually offered. That's a wrongful dismissal, not appropriate. And by the way, bonus. He's asking this bonus to get included. Absolutely. When it comes to your severance, it must include all components of your compensation: salary, benefits, bonus, pension, car allowance, you name it, stock options. everything must be included. It's not just your base salary. So first question is, how many months am I getting paid? And number two question is, what is included in it? Must include everything. That's why you call me. We have to make sure that you got proper severance. In most cases, 90% of the time, whatever you've been offered is not even close to what you're owed.
You know, Lior, quick question. I don't know if it applies to this caller, but if you're in the type of job, say a sales position where your income can fluctuate week or month to month, how do you calculate a severance of, 6 or 7 months? It's going to be all over the place, yeah?
For many people, that's their reality. Some months are good, some are not good, some years are good, some are not so good. So very simple. We look at an average. Depending on how long you've worked there, we look at a 1, 2, or 3-year average, and we use that figure to calculate your severance. So if over, let's say, 3 years, your average income is $72,000, that is the figure we're going to use to calculate severance. Even though this last year, maybe you only made $40,000. But if your average is 72, as an example, that's the figure. Oftentimes, employers will use the most recent pay. And that may not be an accurate reflection of what this person's compensation is. That's why we have an average.
And with that, we'll take a short break. Lior, get to phone call number 3 and our main topic, of course, on the other side. 5 key questions employees should ask about resignations. That is on the way as we continue more of the Employment Law Show. Stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the Employment Lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the Employment Lawyer first at EmploymentLawyer.ca.
Okay, welcome back to the Employment Law Show. Thank you so much for staying with us through that break. Reach out to Lior right there and his team anytime you would like. It's always necessary to get that phone call in to get some correct information and direction. 1-855-821-5900 with an email, help@employmentlawyer.ca. Okay, from our radio show, which can be found at employmentlawyer.ca. We've been doing those for hard to believe, 12, 13 years. We've been doing a lot of radio shows, so a lot of phone calls have come through on air as well. We'll get to phone call number 3 right now, so listen up, pal.
I'm a 35-year employee of a financial institution. I've been in my current management role for 5.5 years. And a week ago, my senior manager verbally told me that they're in the process of changing my job, that every 6 months I do a different job in the bank for a minimum of 4 weeks. What are my options?
Oh, that's an awful situation.
It's a terrible situation. Anyone that would hear that would say the same thing. And because it's a bad thing, your employer is not, or her employer is not allowed to do that. By changing the terms of employment such that now you have a different job and we're going to change job every few months, that is a constructive dismissal. They took whatever her role is and they created something different that's going to change. So she has the option to either accept this new reality. I don't see why she would, but she certainly can. Or she now can get her severance and treat this as a constructive dismissal. It's not legal. Now, what I would tell this employer in writing is say, employer, no, I am not okay with this. This is not something I'm okay with. I want to remain in my current role. And just send that email. If the company or the bank backs off, fantastic. If they don't back off and they say, well, too bad, we're going to do it anyway, she can treat that as a constructive dismissal. Remember, a constructive dismissal happens when your employer makes significant changes to the terms of your employment, to the type of job that you have, to your hours or your compensation, even work location. And if they do that, that may give the employee the right to say no. That's a termination of employment. It's a constructive dismissal. Instead of accepting this, I'm going to treat it as a termination, get my full severance, and move on to a different job.
And the full severance for this 35-year employee, that's a bad one. That's the wrong one to pull the trigger on. I mean, that's what, 24 months almost automatically, yeah?
That's 24 months. You're never going to convince me or convince anyone that a 35-year employee gets less than 24 months. In some cases, it can even be a bit more than that. But 2-year severance absolutely is what's going to be owed here. So really, to kind of summarize it, choices are accept this new reality with, as John said, it's a terrible situation. Why would you do that? Or leave and get your 2 years pay. I think logically in this situation, the 2 years pay, the severance makes a lot more sense.
And with that, we move on to our main topic for the show, Lior. That is 5 key questions employees should ask about resignations. Number 1, we get this one a lot. Do I have to give the standard 2 weeks notice when I'm resigning?
Well, you have to give reasonable notice of resignation, okay? So what is reasonable depends on the type of job that you had and how difficult it's going to be to replace you. If you have a part-time job at a fast food restaurant, frankly, any notice you give will be fine. If you're an executive in a very specialized industry, you're going to have to give a heck of a lot more than 2 weeks pay or 2 weeks notice. So the starting point is to look at your employment agreement. Your employment agreement may stipulate how much notice of resignation you have to give. It may say it's 2 weeks, 3 weeks, 6 weeks, whatever it is. If it does, you should give that amount of notice. If your employment agreement does not say that, or maybe you don't have an employment agreement, you have to give reasonable notice. Now, what is reasonable notice? You really have to think of how much notice do I have to give not to put my employer in a horrible situation, and try to give that amount of notice. But it's not a standard 2 weeks. It really does depend on the circumstances.
Can I be forced, Lior, or pressured to resign? That's the next question we have here.
Absolutely not. Let's talk about what does the resignation mean. The definition of a resignation is something that the employee does on their own. They do it voluntarily. So if someone told you you have to resign, it's no longer a resignation because someone's telling you to do it. You're not doing it voluntarily. So no, you cannot be made or forced to resign. You cannot. And if your employer makes you, the answer should be, no, I'm not. If you want me not to be here, let me go, pay me my severance. But why am I going to resign so that you now can save money and not pay me severance? And by the way, you also won't get EI. So why would you ever do that? You cannot be forced, being made or pressured or threatened into resigning. The only time you can resign is if it's something that you decide to do on your own voluntarily.
We are talking about 5 key questions that employees need to ask about resignation. The third one is this: do I have any rights to severance if I've resigned but it's due to a toxic work environment? What do you think?
So we get severance if we resign because of something that the employer did. I gave you an example earlier about my employer changing the terms of employment, my hours, my pay, my compensation. But what happens if my employer is just not treating me properly? There's a toxic work environment, or maybe my employer is just not fixing the problem. It's allowing this toxic work environment to happen. Well, if you resign as a result of that, that's also a constructive dismissal, meaning you get severance. It's an exception to the rule that you don't get severance if you resign. So really, if you resign for quote unquote good reason, your employer did something to you, mistreated you, changed your job, you may get severance, absolutely. But I want you to be careful here. I don't want anyone to resign assuming they're getting severance without speaking to me first. We need to do this correctly. We need to set it up right so that you can get that severance. So if you think that's it, I'm not treated properly, I want to be gone and get my severance, don't do that until you speak to me. Let's do it correctly. But yes, if you resign because of that toxic work environment and you can show that that's what's happened, yes, you do get severance.
Fourth question, Lior, is can you take back a resignation after submitting one? Kind of like, oh, sorry, I didn't mean to do that.
You know, kind of heat of the moment, or I really didn't mean to. I was having a terrible day. Yep. Generally, yes, you can take it back as long as you do it quickly. And by quickly, I mean before your employer actually relies on it. They're not restructuring the department. They haven't hired someone. So usually if you take it back within a day or two, you can take it back. And if your employer won't let you, say, no, you told us on Tuesday that you're resigning. Today is Wednesday. Well, no, that becomes a termination. If you take it back quickly, heat of the moment, etc., I didn't mean to, I'm good to continue, your employer won't let you. Now they've terminated your employment. Now they must pay you your full severance. But of course, that has to be done very quickly. If you're going to take back the resignation 2 weeks later, that may be too late. So if you want to take it back, do it right away.
Final question is this, Lior, as we're talking about key questions when it comes to asking about resignations. What happens if I resign without getting legal advice from you first?
Unfortunately, there's nothing that you can do. If you decide to resign, you have to live with that resignation. It's always good to seek legal advice, always, before. But even if you've already resigned, let's talk about it. There may still be things you can do depending on why you resigned. There may still be options and compensation. But certainly, unless you're doing something voluntarily, I found another job, I'm retiring, I'm going to spend more time with the family. Unless that's your situation, you're retiring, or unless you're resigning because of that, don't resign without speaking to me first.
And that'll wrap up the main topic for this week. Always reach out to Lior if you have any more questions regarding what we just talked about. But other than that, we're going to take a short break, get to a couple more questions, and the employment rights rapid fire at the end of the show as well. So stick around for that. We're coming right back.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back. Employment Law Show. John Scholes and Lior Samfiru as well. Reach out to Lior. As you know, the phone call, make it before you make any decisions anytime when it comes to your work life. That is 1-855-821-5900 and help at employmentlawyer.ca. Lior and the other lawyers in his firm have them doing the live stream all week. It's a great opportunity to tune in, ask your questions, be it Facebook, LinkedIn, or YouTube. Those are the outlets to do that. And to get on board at stlawyers.ca, at stlawyers.ca. Here's the question for this show. Lior says, I'm the manager of a business that has been sold, but I haven't been offered the same position with the new company yet. My fear is that I will be kept on by the new owner just long enough to train a new person and then let go, sacrificing a substantial severance, 20 plus years of service. I'm almost 50. I don't think this person quite understands how it's going to work, Lior, but break it down for us. What do you think?
Well, let's do just that. Let's break it down. Let's break down what happens on a sale of a business. So the first thing that can happen, of course, is you're not getting a job at all with the buyer. You're going to lose your job as a result of the sale. There's no job for you. Well, in that case, of course, you get your severance. If you don't have a job anymore, the business is sold, you get your full severance from the seller. They have to pay your entitlements based on your age, position, and length of employment. That could be as much as 24 months' pay. Now, what happens if you are offered a job by the buyer? If you're offered a job by the buyer and you take it, then they inherit your service unless you sign an agreement that says otherwise. And down the road, if they let you go, then they have to pay you your full severance based on all the time that you've spent. Now, if you're offered a job but you don't accept it, you may still be owed severance depending on the reasons you didn't accept it. And that could still be a substantial amount. So, of course, the best advice is not to reject an offer or, frankly, accept it without speaking to me first. But if this person, going back to this call, if they're going to be offered a job and then lose that job, that absolutely can happen. But they should be getting severance based on all the time, including their time with the previous company. So the last thing we have to now assess is how much severance would they be getting after their 20-plus years of service. For that, we're going to go back to pocketemploymentlawyer.ca and use our severance calculator. Let's do that right now and see how much severance this person gets. So a manager, 49 years of age, been there for 21 years, a long time. We don't know yet what severance are going to be offered, but we do know that this person is owed anywhere from 18 to 24 months of severance. 18 to 24 months, a substantial amount. So yeah, he could be made to train a replacement. But if then he is let go, he doesn't lose his severance, he gets his severance. So don't sign anything, whether it's an employment agreement or a severance package, without calling me and speaking to me first.
All right, Lior, next question comes from our website, terminationquestions.com. That is for you to use anytime. It's free and anonymous. Ask your questions. It may appear on this show at a later date. We'll get answered regardless. Here it is. I've been employed for over 4 months as a project manager and was fired. The company says I don't get any severance because I was still on probation. I didn't realize probation could extend past the initial 3 months. Do I have any legal recourse for severance?
The old probationary period. Like, John, you and I have done radio shows just on this topic before. So it's actually fairly simple. The only period of time that you can be let go without severance is the first 3 months of employment. And even then, that can only happen if you sign an employment agreement that says that specifically, because probation is not automatic. But what does that mean? After you're done your first 3 months, you can still be let go, because remember, your employer can let you go pretty much at any time, but severance has to be paid. So your employer can't say you're on severance for 4 months, 5 months, 6 months, and use that as a basis to terminate without severance. They can call you on probation if they want to, if it really makes them happy to do that, but it's irrelevant. They have to pay you your severance. And by the way, even after 4 months of employment, your severance is going to be substantial and measured in months, not days, not weeks. You could have worked for 4 months and be owed 4 months of severance. So whether your employer says you're on probation or not, whether you've been there for a few months only, doesn't matter. Call me. You'd be surprised by just how much you're legally owed.
And it is time with that, Lior, for Employment Rights Rapid Fire. Strap in, pal. Here they come. Okay, rapid fire number question, Lior, is this: can my employer deduct pay as a disciplinary measure? What?
Yeah, what? No, absolutely not. Your pay is sacred. Your employer cannot avoid paying you what you're owed, even if you've done something wrong. Frankly, even if you've made a mistake that cost the employer money, they're not allowed to deduct that without your consent. Certainly not as a disciplinary measure. You have to get paid what you're owed, full stop.
Rapid fire number 2, can my employer ask for details about my medical condition? Wow.
We touched on that earlier, and the answer is absolutely not. Your medical condition, the specifics of your condition are private, it's personal, and it's none of your employer's business. Your employer can ask how long you're going to be off. Your employer can ask, is there accommodation that can be given to you? Those are legitimate questions. But beyond that, not what your medical condition is, not what treatment you're getting. That is offside. They're not allowed to ask that, and you should not give that information.
Rapid fire question number 3. Can my employer refuse to accommodate if I have child care obligations?
Well, there's an obligation to provide accommodation if the only way you can care for your child is through accommodation by the employer. So that doesn't mean that your employer has to jump in right away and say, we'll accommodate. But if you've looked for other solutions and there aren't any, and the only way you can provide care is with that help and support from your employer, under human rights law, they have to do it. And if they don't, that's a human rights violation, and you should call me.
All right, rapid fire number 4. Can my employer fire me over text messages or social media?
It is legal, not right, not cool, not professional, but there's no law that prevents that. So yes, your employer can let you go in an electronic form.
And our finally rapid fire question for this week, Lior, do independent contractors have a right to severance? Always get that question.
Always, yes. And in most cases, people that believe they're independent contractors, in fact, have been misclassified. They're employees being called something they're not. And that means, yes, they're owed their full severance.
All right, we got it in. We're about to wrap for the day, but I always leave you with the contact information. Very important part of the show, right? 1-855-821-5900, help@employmentlawyer.ca. We'll catch you next time right here on the Employment Law Show.